Hi, my name is Laura Leonard, and I'm an associate in the Privacy and Cybersecurity team of Hunton and Kurth in Brussels. Today, I would like to give you a quick overview on employee data processing in the context of the COVID-19 pandemic. The COVID-19 pandemic is forcing organizations to take extraordinary measures to ensure employee safety and protect business operation. And of course, these measures often involve processing, including sharing of health-related data. Before I give you an overview of the general principles that apply across the EU when it comes to employee data processing in this context, I would like to make very clear that the exact requirements and limitation around the processing of health-related data of your employees will largely depend on the laws, regulation, and guidance issued at member state level. Most importantly, EU data protection authorities have issued differing guidance on a number of questions regarding employee data processing in relation to COVID-19, such as whether employers may conduct body temperature checks, require employees to provide information on symptoms, potential exposures, or travel to high-risk areas. So overall, I would highly recommend you take a look at what has been published in your country. Now let's take a look at the requirements that companies must take into account when processing their employees' personal data for COVID-19 purposes. First and foremost, companies must ensure that for each of their processing activities, one of the legal grounds listed in Article 6 of the GDPR is satisfied. If a data processing activity involves sensitive personal data, such as health-related data, one of the more stringent conditions set forth under Article 9 of the GDPR must also be met. Typically, organizations may only process health-related data of their employees in limited circumstances. In this case, generally, organizations should be able to invoke their legal obligation to ensure employees' health and safety, reasons of public interest, and/or the employees' or other individuals' vital interest to legitimize the processing of employees' health-related data in the context of the COVID-19 pandemic. As mentioned, however, specific DPA guidance will need to be considered. In addition to lawfulness, organizations should also ensure compliance with the key data protection principles under the GDPR, and this includes proportionality and data minimization. Under these principles, organizations should limit the processing of employees' data, in particular sensitive personal data, to what is strictly necessary to achieve the objectives pursued by the measures. For example, that would mean not recording data obtained in connection with body temperature checks. Organizations should also make sure they are transparent and provide employees with transparent notice regarding the processing of their personal data and sensitive data for the purpose of COVID-19. Particularly, these notices should include information on the purposes for which data is collected, with whom the data will be shared, and for how long it will be retained. Finally, organizations must ensure that appropriate measures are in place to protect personal data collected for COVID-19 purposes, taking into account the sensitivity of the data. And with that, I would like to finish with a recommendation, which is for organizations to monitor the evolution of DPA guidelines as the fight against the virus evolves. Thank you very much for listening.